the LSA's process in tenure regularization starts first with your certificate of comfort. And this document, I can't reiterate enough, needs to not be mistaken for a deed. It is not.
Please. Repeat that again, please.
Yes. A certificate of comfort is not a deed. A certificate of comfort is not a deed. Please, it does not have any of the legal power, identification, or features as a deed. It is a certification that protects you from ejectment from state land. It is stage one of the regularization of the title process for you as a squatter. It is not transferable. It is a personal right or permission or certification that the state gives you to say, okay, you have the right not to be ejected for now. You're starting the process. We see you raise your hand. You're on the land. You want to get regularized. You cannot sell the lands by virtue of a certificate of comfort. All right. So that is it. So this is a process thing. So stage one, certificate of comfort. Stage two is, and we're seeing the raising hands, we're seeing the questions going to come to you. Stage two is your statutory lease. These statutory leases are usually 30-year leases, and it's a process that allows you to wait for the creation, development, and establishment of your deed of lease, which is your third and final stage, which is your lease between you and the government, giving you a leasehold interest, usually in 199 years of the land ownership. So you'll get leasehold ownership in your lands. All right. So you can consider it as under the LSA in 3 stages. Stage one, the squatter gets security by the tenure on state land by the certificate of comfort. Stage one, statutory lease. Stage two, deed of lease. Stage three, it is a process.
Right. Might I add to that really quickly that the certificate of comfort, just to kind of give us another spin to it, is simply your permission, is almost like your receipt that you have started the process. It is simply to say you have begun the process of tenureship for the lands on which you reside, right? And so even for the private owner, somebody might come, you might come, and somebody say, yeah, I'm here for 15 years, and I have a certificate of comfort. That certificate of comfort, I don't know where it came from, but it only says that they are going through the process. It does not give any further authority than that.
Right. Thanks for clearly explaining that, because, you know, in Trinidad, persons like the document, having a document in their hand. I think it really empowers them, but it's good to know the weight of that document. Mm-hmm. And in my remit as a real estate agent, I've seen many persons come and say, listen, I have this document here. I know I can't do it legally, but I want to sell my interest in the transaction. So, you know, how does that work? Can you sell your interest in lands? I've occupied these lands for 20 years. I want to sell my interest in the land, my rights to this land.
Now, that is a very interesting concept, Mr. McLean. The answer is it depends, as many things in law, right? There is yes and no. There are many attorneys at law who have no difficulty in creating documents such as those, because you can, but you shouldn't. You know, and we're going to reach that question because, you know, in land, property law is such an intricate thing. Interest is there, of course, but when we're talking specifically about this one, a certificate of comfort holds personal interest. That interest is not transferable. It's not like other interest and entitlement. Let's say, for instance, interest under probate. persons may sell their probate interest. You may have a squatter interest. I've seen squatters sell their interest to apply for certificate of comfort, but not after getting a certificate of comfort from the government. That interest is absolutely not transferable for sale. Okay. And again, we remind clients and the listening public that not because something is registered means that it is legal. So you may very well have a document that has been registered, but the legal enforceability of the document can be questioned and challenged, and once found to be not substantive in law, can be set aside and your interest extinguished. I want that to be reiterated. Again, not because a document, especially under the common law, has been drafted and created and registered means that it is legally binding. It can be challenged, and once successful, can be extinguished and set aside as having no bearing in law.
Very interesting.
Very important.
Yes, very interesting. Thanks. So, Ms. Daniel, I got the sense that you were saying that squatter on state lands, the process is different for a squatter on private lands to regularize. Did I get you correct there? And if you just want to explain that a little bit first.
So the LSA is a state enterprise, right? And they have identified that this is the stages that they want to implement. Certificate of comfort, statutory lease, and then your deed of lease. Now, a private landowner who have squatters could decide to follow something similarly, but will not be able to give a statutory lease because you're not the state. Statutory is from the states. You can't give a state lease, right? But you can make a rental agreement with your tenants, because as a landlord, you can make a bona fide or bona fide rental agreement or a short-term lease with your squatters, regularizing them in the manner that you're moving them from being squatters, and you're identifying that, okay, I want to give you all interest in the land. I am making an agreement saying that this is my intention, this agreement is binding, and we're starting a process with each other for me to help regularize your existence on my land. Because sometimes the reality is, sometimes people, we have a client who inherited 60-something tenants. Over 100 and something years they're there. He's now the great grandson that come and see these people in these lands. It does not make sense to try to eject 60-something people who have concrete houses and roads and stuff on your land, when you could sell them the land, even at half the market value right now. Let's say each plot is worth 500,000, and they say, okay, I'm willing to make an agreement to sell you all half the market value, 250,000, and you have 60 tenants. That's your sell, and they give the people their papers, so to speak, so that they can now give their children. They could either sell the property they own, they can mortgage the property, they could pass it on, etc. You're giving them their papers, and this is really something we're encouraging. A lot of private owners do not. It sometimes does not make sense to get into spending money for litigation to get squatters off your land if you have squatters willing to buy, right? And they have developed for you, So a case like that, we want to encourage. There is no LSA for private lands. You can find law firms, legal firms who are willing to go through the process with you to provide that support. We are one of such firms, and see how you can, do a similar process for yourself as a private landowner. What makes the most sense to deal with your squatters?
Yes, that's a very interesting concept, because we know many persons in Trinidad, especially back in the day, as a real estate agent, I would have seen persons buy land and get a receipt. Literally like a receipt from a book, and that's what they have as ownership of land, right? So we're saying that, to go and bring those matters to court to fight where we are in the stream of time. I mean, it makes more sense to try and regularize your tenants or your squatters.
Correct.
So thanks for mentioning that. Thanks for mentioning that, Ms. Daniel. Mr. Paul, let's see if we can get a little more information from you on how costly this process is? Because I'll give you an example. Let's look at maybe Laventille. You have hillside properties, squatters, and I mean, there would have been no major civil engineering being done to construct these structures up there. So how does an individual move the land from where it is now to getting that infrastructure in? Are there government assistance programs? Are there what is there to help regularize that infrastructural process?
Okay. So I will take it from the LSA side, and then I'll move it into the private lands, right? From the LSA side, the LSA's responsibility is to create councils and to create the infrastructure, or the hierarchy, or the committees that go about establishing the process, problem solving, and solution orientation of land and land development. So the LSA will have their own particular grants, they will have their own particular criteria for those grants, and so it's important to be able to ask you to be able to have that knowledge, especially if you would like to develop or help develop certain plots of land, especially if it's within the arena or the areas or the designated areas of the LSC.